Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we are going to discuss a subject which is important for any healthy democracy. The subject is democracy, courts and the rule of law. Our panelists for this discussion are Justice A.K. Sikri, Judge, Singapore International Commercial Court. He's also a former judge of the Supreme Court of India and the incumbent chairperson of the News Broadcasting Standards Authority. Justice Michael Wilson, sitting judge of the Hawaii Supreme Court, USA. He was appointed to the Supreme Court after having served as a circuit court judge of the First Circuit since May 2000. We have Justice Matthew Cooper with us. He is a justice of the New York County Supreme Court, USA. He is the chair of the Board of Justices of the Supreme Court, First Judicial District. He is also on the executive boards of the New York State and the New York City Associations of the Supreme Court Justices. Professor C. Rajkumar is with us today on the show. He is a well-known public intellectual and the founding Vice Chancellor of the Jindal Global University. A Rhodes Scholar, Professor Kumar has academic qualifications from the University of Oxford and Harvard University. So as you can see, we have a diverse panel. We have people from the academics as well as somebody who set up a university. We have got a former judge of the Supreme Court who's also now with the Singapore International Commercial Court, as also we have judges of the Supreme Court from America. Let's begin our discussion today. I'll start with Justice A.K. Sikri for his opening comment on the state of affairs between democracy and judiciary. Sir, your opening comment.
You see, over a period of time, if we see the history, there have been different kinds of systems how the society is to be governed. It is not necessary to go into all that debate, but what is important is that in last 150 to 200 years or even little over 200 years, if we give the example of US, the constitutionally governed democracies have come up, and the trend got momentum after the Second World War, and the Holocaust which it created, and it was thereafter felt by various countries that look, there should be systems which are governed, which should be governed by some written instruments. And over a period of time, and many countries now, more than 100 countries have their own written constitutions. Now, in almost all these constitutions, you will find that they have to be democratically governed. In very simplistic terms, if we say that the democracy is where the people elect their own representatives and the majority rules. But the decision who should be the ruler or the governance should be at whose hands, that is to be decided by the people of the country, and in a particular country, that the society which decides it. And therefore our constitution also, like US constitution, it says in most of the constitution, we the people. Even the constitution is created by the people for themselves. Now, as I said, that this is a very simple way of narrating what the democracy is, that it is the governance by the people, for the people, and for themselves. But then at the same time, it is only not limited to this, that the elections take place, the people vote, and the people, whichsoever party, political party is majority, that forms the government, and that would rule. But then at the same time, the constitution and all constitutions, including of US and India, there is a system of governance there. There are some parameters which are laid down how the governance would take place. And we know in almost all these democracies, there are three pillars of the state which they are known as. This legislature, which is one which makes law, executive, which enforces the law, and which implements the law, and the judiciary, which enforces the law. So the three these pillars of the state, it is also like in our constitution, it states that the both will their rights, their powers, etc. are defined in the constitution. So they have to work within the limits which are defined in the constitution. And we have the system of separation of powers as well, that one wing of the state would not interfere with the work of the other wing of the state. At the same time, in this entire process, and without giving this thing in detail, which we'll discuss later, but then at the end of the day, in the Indian Constitution, which we again concept which we took from United States Constitution, was that is of judicial review. That is that ultimately it is the judiciary which has to judge, if it comes as a judicial review, whether a particular legislation enacted by the parliament or the state legislature is constitutionally enacted or not, or whether this is called judicial review of legislation, and whether a particular act by the executive is legal or not. This is judicial review of administrative action. So therefore, ultimate power is given to the judiciary, and in this, as I said, that there are checks and balances, in the sense that one limb of the government checks the other limb of the government, all that is provided. So this we can say broadly, can state is the way the democracy functions. But as I said, when we proceed further, we'll try to deal with other nuances as well.
Okay, interesting comments. Justice Wilson, your opening comment on the state of affairs in relation to democracy, judiciary.
Thank you, Tarun. And being in India provides a context for this idea of democracy and the judiciary, because as Justice Sikri pointed out, there's been a long history, hundreds of years with respect to the United States, of the idea of the rule of law applying by the judiciary to make sure that the laws are being followed by everybody, regardless of the power that they have or the wealth that they have. The laws have to also be followed by the legislature, and they have to be followed by the executive, and the courts have the great opportunity and the responsibility to define what it means to follow the law. But if you move into a contemporary context, what is democracy in terms of the rule of law now if it isn't seen from an international perspective? Because so many issues have become broadly international. And part of the reason that my brother Justice Cooper is here and I'm here is to get knowledge and to some extent leadership about these very important international issues, because if you think of what the future is going to be like and the court's role, take surveillance, for example. Yes. The idea of power being given to government that is absolutely beyond any precedent, the power to keep track of every citizen. Yes. Well, if we are to be concerned about freedom and the freedom of individuals under a constitution, and our constitutions are very similar, they both have a focus at the beginning on we the people, so the democracy is supposed to be power that comes from the people. If we're concerned about the everyday quality of life, well, courts are going to have to decide how much can a person be surveilled in the future. This is a role of courts internationally. And finally, if you take the 850 million people that are of an age less than 30 in India and look at their future, 50 years from now, when, for example, Bangladesh has to be evacuated with 160 million people, there'll be so many issues that are international that a great Supreme Court like India will have to face to some extent before our courts in the United States, because India just happens to be on the cutting edge of that very, very serious issue of climate change. Yes. So contemporary democracy, contemporary judiciary means to some extent now we have to be thinking internationally and thinking together.
Some very interesting points by Justice Vincent. Now I'll go off to Professor Rajkumar. You had someone who have had the experience of staying in about 3-4 countries. As far as I know, you've spent time in Hong Kong, America, and the UK, and experienced democracies in these countries, especially because you're associated with the field of law. How would you look at democracy in relation to judiciary and rule of law in different countries?
So, I mean, as our distinguished judges said, that at least in the Indian context, we never had a choice of not having a democracy. The founders of our republic were very conscious of the fact that they were trying to create a society which was so diverse, so much of inequality, so much of different religions and castes and languages. So democracy became an opportunity for binding people, and so there was no choice whatsoever. For India, it's not a choice to be a democracy, it's an imperative that India can be nothing but a democracy. But having said that, the founders were also very conscious of the fact that they were participating in the freedom movement, and they were resisting, what was another democracy in its own right, and which was implementing an authoritarian form of governance in India. And it was ruled through law.
Yes.
And so when they were writing the constitution, they were conscious of the fact that they were actually creating a constitution for themselves, but at the same time, they were creating a situation whereby those people who are going to hold power within that constitution should be made accountable as well. And it was quite an extraordinary moment, because rarely in history where the people who are writing the constitution are also directly involved in the creation of a new republic and will also be the early holders of that power. And so because they participated in the freedom movement themselves, were conscious of the autocratic and undemocratic rule that they were witness to, they were very conscious of infusing a lot of provisions in the constitution which protected rights and ensured freedoms. But also they recognized the role of the courts, and that made it so, in many ways set the tone for how the relationship between the legislature, the executive, and the judiciary will be. And of course, it took many more years later in the functioning of our democracy for us to determine what is the nature of that relationship, because clearly, if you look at the UK context, Parliament is supreme, but India went through a lot of evolution for us to ultimately determine that actually in India, it's not the courts are supreme, it's not the legislature, it's the constitution which is supreme. And that is an evolutionary idea,
Yes.
and in many ways also a revolutionary idea for it to have deeply embedded in the political and the civic culture of India.
Interesting point, as I see, made by Professor Kumar, also because if you see the kind of countries that got independence in South Asia, how many of them are democracies today or masquerading as democracies today? We all know that, but that's another discussion. Justice Cooper, your comment on this important issue.
I was hoping that you'd have me speak after Justice Wilson, because it's always very hard to sound smart after Vice Chancellor Kumar speaks. He's so brilliant, but I will do my best. And this is, unlike Judge Wilson, is my good friend. This is my first visit to India.
Yes.
Justice Wilson has been many times, and my wife and I have been struck by so many similarities between India and the United States. These are vibrant, swirling, not often tidy democracies. And I've also been struck by the significant major points in governing that we share. Above all else, we are two nations that have written constitutions. We have the oldest written constitution. You have the privilege of being the largest constitutional democracy in the world. And the things that I've learned, other than, of course, that we start with the same preambles, we the people. We have a very powerful 14th Amendment to our Constitution. About a great deal of our social change has come through court decisions that have applied the 14th Amendment. You have Article 21 of your Constitution, which certainly envelops major concepts that we find in the 14th Amendment. But I think, to echo what the other members of this discussion have said, is that unlike other countries, our two nations have a commitment, and hopefully will continue to have the commitment, to having three branches of government that are co-equal. We recognize how important it is to have checks and balances. Both our countries are faced often with challenges where those checks and balances might be called into question. And we have system of government where the ultimate body that determines what that Constitution says, the ultimate body that interprets the Constitution, is our Supreme Courts. In our case, the Supreme Court of the United States, and yours, the Supreme Court of India.
So now taking on from here, I'll go to Justice Sikri. Sir, I want to know from you this specific thing on, now in India at least, as I have seen, and I can speak from the Indian Express, that our Supreme Court has been called upon to tackle different types of crises, from water disputes between states to midnight formation of governments. And courts have come to the occasion. We have covered midnight hearings at 4:30 a.m. in the morning, and there is
I was a party to one of that.
and sir, there is a sense that that I get when I speak to people across the country, especially who are from the government, that the easiest way not to decide something and absolve myself from the responsibility is just toss it to the courts and let them decide. So when the executive, when it doesn't want to work, just put the ball in the court's court and let the courts decide. Do you think the courts are being made to do things which wouldn't have been, in a sense, expected of them to do, but now they are doing everything from policy making to the kind of disputes? But you're the best judge, so I want to.
Let me deal with this this issue which you have thrown open in two ways.
Yes.
One is where we left, all of us, in our preliminary round when you asked the first question.
Yes.
And so in this entire context, and what are the conditions in which we are going, and what is the international scenario, as Justice Wilson also pointed out, how the Indian Supreme Court has evolved,
Yes.
and then come to the issue which you have raised, because there would be some connect between the two. Now, we were talking about democracy and the role of courts in that. You see, one simple way, as I said earlier, what is the role of the court to decide the dispute between the parties which are filed in the courts. So, but that would be a simplistic view, as I said earlier, and going by what our constitution expects from the judiciary. When we talk of democracy and when we talk of rule of law, I would say that the first and fundamental role which is assigned to the judiciary is to uphold this democracy and to uphold the rule of law. Yes. So that has to be in all given circumstances. Other role which is ascribed in Indian context, and which is relevant in many countries, and it may be in maybe in a different context, but may be relevant in the case of US also. And going by the fact that we, in 1947 when we got independence, and in 1950 when we gave ourselves this constitution, India was one of the poorest countries. Yes. And poverty is still there. Yes. So we have marginalized people, we have deprived people in our society. So therefore, over a period of time, and having regard to the chapter on fundamental rights, which was pointed out by Professor Rajkumar, and another chapter on this directive principles of state policy, and how this has been interpreted over a period of time, and many aspects of directive principles which are not enforceable otherwise have been brought into the contours and scope of the fundamental rights, particularly Article 21, and how those have been enforced is a enlightening history, and where the contribution of the Supreme Court is remarkable. But what I am saying is that second role from this, first role I said to uphold the constitution and the rule of law. Second role is, here it comes to bridge the gap between the law and the society.
Bridge the gap
between the law and the society, wherever this gap is there. So that is the role over a period assigned. Now what happens actually, now third dimension which we feel now is happening particularly in last few years in various countries, and I will include US and India as well, is the kind of, you see, we started, as Justice Wilson said, that today international, we have to see it from international angle. There are boundaries, geographical boundaries are getting blurred, etc., particularly after globalization. But at the same time, a parallel thing which has started at least in last couple of years is, and particularly after 2008 when there was an economic recession in the world, parochialism has again been brought into.
Yes.
In many countries, they feel that, look, no, we have to first take care of the people from our country. And so I'm not, I think I'm very clear in when I'm saying so, and I'm not giving the examples, etc. Now, on the one hand, we talk of liberal democracies. So in a liberal democracy, the power of the state is limited.
Yes.
Right? Even if it is an elected government, so majoritarianism would not rule in that sense. Minorities also, and the other section of the society also have a right to say in the governance. That doesn't mean that they are totally deprived of it. Now, Hobbes had given us the social contract theory, where he had created a Leviathan state, if we see. And the purpose was, the objective behind his Leviathan state was that, look, if we don't have, and that is how the democracies came into being, we don't have an organized society, and in an organized society, it would be Jungle Raj, and the mighty person with this can rule and say, so therefore we can't have that kind of anarchy. So that is why he said Leviathan state, where it would be people would elect their representative who will govern. But at the same time, the state, and these are some of the stories in last few years, if you see Turkey, Libya and other countries, where the state also become despotic.
Yes.
So therefore, how to control that? So the new theory which is emerging and which is now projected in last couple of years is that we have to have a state, the state has to be there in a democracy which should rule, but then it should be a shackled state.
Shackled state.
Shackled is the expression which is used. It should be a shackled state where society should have a right to project its voice even against the elected government, if elected government is not going ahead and as per the constitutional norms, etc. Now, having said so, in our Indian context, where of course now recently in a different context, there's so much of protest, etc. I'm not going into the merits whether protests are good or protests are bad, but then over a period of time and in Indian context where the people have not been able to raise their voice otherwise, it was, and the history has shown that it is left to the judiciary.
Yes. Sir, if I may
now, in
interrupt,
that context, I come to your second aspect, which you said. Should I answer that
no,
just now?
Just before you answer, I want to briefly interrupt you.
Yeah,
Professor Kumar raised an interesting point when he said that it's not the judiciary which is supreme or the parliament, it's the constitution which is supreme.
Exactly.
Would you agree with his?
Yes, yes. I agree 100% with him, because even it's not only the legislature or the executive which has to function within the framework of the constitution. That is the duty of the courts also. That is the duty of judiciary as well. As I said in my opening remarks, that the scope and the powers of all the three wings of the state. So
you are in agreement with the theory?
Oh yes, yes, completely in agreement. But what I said was, and that makes important is, ultimately suppose if a particular law is enacted, I am giving an example, by the parliament, and the validity of that law is challenged. Now, in the court, the government would come, Union of India would say that no law which is passed is constitutionally valid. Right? The person challenging would say that no, it is not, because it offends, say, Article 14, Article 19 or Article 21 of the Constitution or any other provision of the Constitution, or it is ultra vires. It was not within the powers of the parliament to enact such a law. This power is given to the state legislature, etc. So these are the grounds on which a law can be challenged. But then who is to decide? Here judiciary comes in. So therefore last word is with the judiciary.
This is the last word, but you're not saying that judiciary is more powerful? Or
no.
It's the constitution which is powerful.
It is constitution which is powerful. No doubt about it. Now
answering my question.
Yes, now I come to your question which you asked me, that the tendency has become, you see, there are, as I said, about directive principles of state policy. Now, directive principles of state policy are various principles enshrined in that chapter, as per which they lead towards good governance. They are aimed at creating an ideal society, equalitarian society, which is more, economically also, which gets more prosperous, etc. That was the aim, as Rajkumar rightly pointed out while of the framers of the Constitution.
Yes.
Now, those are the duties which are cast upon the executive, that you frame such policies which are good for the people, for those who are downtrodden, those who are marginalized section of the society, their standard of living, etc., should be raised. There, all kinds of this are there. Now, executive, over a period of time, it was seen, has failed. That is the perception of the people, that the executive has failed in its duty to bring about. I am not at all commenting that, look, in last 70 years there has been a lot of progress made by India, economic progress, and on social front also. So credit of this goes to executive as well, the government as well. I am not saying that, but in many ways.
You mean there are aspects where there are grievances?
There are grievances. Yes, there are aspects where there are grievances, and it started, say, in of course in 70s, and when we have that, we call it a socialist era, when we had justices like Justice Krishna and Justice Bhagwati and Justice Chinnappa Reddy, etc. And this is called socialist period that for social rights in that sense. So therefore, those kinds of causes started coming, and Justice Bhagwati, he started that public interest litigation, which is called social action, litigation as far as US is concerned. So at that time it was thought that, look, there are some of the unprivileged section of the society, but because of their poverty or because of their illiteracy, they are not able to bring these causes. The court started doing this.
So, what you are indicating, that there are grievances which the courts, people came for the courts for redressal, and courts where it was not suo moto. It's people who went to the courts, and then of course the courts keep on getting involved because people saw results.
And to some extent, although they went, but initially it was suo moto as well.
Suo moto as well?
PIL, the courts also started taking up those issues. A particular news item appears in the court. If you see the history of 80s and 90s, now we have many public spirited persons
who are doing PILs.
Earlier it was suo moto. One day some incident takes place, you see, within 24 hours, less than 24 hours, writ petition is filed in the Supreme Court challenging that action.
So earlier it was not the case.
But earlier it was not, in 80s, etc. It is the court which gave impetus to this as well. And so what happened, then you see that if we see the history of PILs, public interest litigation, or the kind of litigation, we'll call it, and it is stated also in one of the judgments in 2010 by Justice Dalbir Bhandari, State of Uttarakhand versus Balwant. He has said that 3 phases of PILs. First was this phase, that for unprivileged class of people who can't come to, and the scope of locus standi is extended. And so therefore the courts, any public spirited person who is not concerned with that case, but he can come and file a case on behalf of others. And the courts can also take up the suo moto. And not only that, you can, in order to see that the procedure should not be, the normal procedure of filing petitions, etc., was also given a go by. You can even write a letter and post it and write it to the Supreme Court. Supreme Court will treat it as a petition and all. So this was the first phase. Second phase, if you see, which happened when the environmental laws relating to environment, that our ecology, our protection of forests, protections of these rivers, etc. And there's so many judgments of that kind which the Supreme Court started adopting, because
now I'll just, we'll take a moment, we'll go to Justice Wilson at this point. You've seen Justice Sikri share the Indian example. Now a lot of my viewers, our viewers, not acquainted with what happens in USA. Could you share with us, have courts in USA been called upon to tackle these kind of crises, specifically with regards to governance, specifically with regards to issues that people have? What has been the US example, or it differs state by state? Could you share with us?
Thank you. Well, I'm happy to talk about some of the history of the rule of law in the United States. And let me say that in doing so, it's important to recognize, as Justice Sikri has said, this concept that we share, as Justice Cooper said, of democracy being we the people, because That's a powerful term. It means that there's an assumption that the people are not going to be protected if you only have the executive branch.
Okay.
Democracy is not going to be healthy if you only have the legislative branch.
Yes.
You need an institution called the judiciary that will guarantee the rights of, and this is where it gives me a lot of inspiration and, as we say, chicken skin to think about, where does Mahatma Gandhi come from?
Yes.
Where does Ashoka come from? It comes from a history of standing up for the underprivileged in a huge population called India.
Yes.
So let's move to the United States. We have the same assumption that we have to be careful about our government.
Okay.
The state, as Justice Sakri said, we have to be careful.
Careful.
This underlines all the relationships between the judiciary, the executive, and the legislature. We have to be careful not to give government too much power. And the guardian
Yes.
of that are the men and women who are trained. And when I hear Justice Sakri, it's just an echo of the justices of the India Supreme Court who have been trained to be independent and vigilant under, for example, public interest law, which is developed in a robust, powerful way in India and also has developed in the United States. But it means that people left out, people that are poor, people that are oppressed, have a voice with the courts. In terms of examples in the United States, imagine we had a history of slavery.
Okay.
What is the role of the court when you have the executive and the legislative branch that are pursuing the policy of slavery? It was challenged.
Challenge, yes.
At first, because of the pressure, institutional pressure, the court said that slavery is constitutional. That was hundreds of years ago.
Yes.
But then it's a living constitution. Then principles that are quite clear through, I think, a straightforward human conscience prevailed. And judges were independent and said that slavery, of course, is unconstitutional. If you move forward to an industrial era, this idea that there were poor people or children in factories that were being exploited, they needed to be protected. There was legislation passed that went to the Supreme Court because the government, the executive, wanted no regulation of business because it might make business less efficient. The courts had to decide. And at first, because the men and women came from this sort of industrial community, the court said it's unconstitutional to regulate the conditions of children working in factories.
Is it so?
At the beginning.
Yes.
So when we look to India and we see the tradition of judges being so independent and willing to declare that the Constitution means you have a right to life, you have a right to a clean and healthy environment, it helps fortify our judges. And our judges eventually decided that, of course, under the Constitution, it's probably good policy to control the conditions of children working in factories because you can't just leave it up to the powerful industry. And finally, we now have a challenge on the ultimate public policy issue, standing up for a whole generation of people that are less than 40 years old. And where are most of those people in the world
India,
that are less than
South
40
Asia.
years old? They are India by far, with 850 million people, a lot more than in the United States.
Yes.
But do citizens have the right to come to court and demand a clean and healthy environment?
Yes.
It's not so clear right now in the United States anymore.
No?
But it's clear in India.
In the US, it's not clear as yet.
It's no, and this is part of the reason that Justice Cooper and I are here, because it's so important for us to see the way India handles these kind of problems.
Very
But this is a very, very fundamental issue of great
A
importance.
bunch of interesting points by Justice Wilson. I'll go to Professor Rajkumar.
I want to quickly respond to
Yes,
what
yes,
Justice.
yes.
You see, it's very important to also recognize that when you look at our own courts, while Justice Wilson is right to say that the demonstration or recognition of the right to clean and healthy environment in the US context is not so clear, and the Indian context, our courts have consistently recognized that. But we should make an important distinction between norm creation and norm recognition does not meet norm enforcement or implementation. It continues to be the case that a lot of, let's say, directions that have been issued by our courts, recognitions relating to what is right and what isn't, have not been implemented effectively. So we have a situation in our country, and that's a far more serious situation, in which on a number of issues, particularly in relation to economic and social rights, including on issues relating to environment, the court orders and directions have not been followed. And there is an exponential rise in the norm creation, but when it comes to actual norm enforcement and implementation, we are slowly becoming a very weak state. And unfortunately, our courts don't have enough mechanisms, because to a large extent, it's important, Tarun, to recognize that democracies, to a large extent, work best when all institutions are by and large performing its role and responsibility without the force of law. In the sense that, as a famous jurist said, rule of law works well in societies which already respect the law. So in some ways, if in environment, it's a very important area, because all of us grew up in law schools, reading those famous judgments on range of issues where we expanded the right to jurisprudence, including Article 14 and 19 and 21, which we are very proud of it. But the fact remains that we are increasingly entering into a stage where courts can keep making these normative judgments, but the institutional capacity and executive responsibility to enforce and implement these judgments are weaker, and I dare say we don't have enough mechanisms to ensure that the executive is held responsible.
Very, very important point by Professor Rajkumar. I've personally experienced this, because in my career, say for about 15 years or so, I have seen that courts have, in a sense, have orders upon orders where they have delved into issues like clearing of garbage from certain societies, to supplying water to non-VIP areas where, because water is supplied to certain enclaves in cities where a certain section of society lives, where government officers live, or in a sense, the better off neighborhoods of cities. So all kinds of issues courts have been getting involved into. Of course, not suo moto, people have been aggrieved and they have approached the courts. But of course, it is for us to see, and many times I have personally witnessed that these orders are not implemented due to sheer executive, there can be two kinds of inferences drawn upon: unwillingness to implement with whatever they have, or simply saying that there is not enough wherewithal to implement.
Resources are not
there.
I'll use the word apathy and indifference.
Apathy and indifference. So going to Justice Cooper, and you've seen all other panelists speak, and what would be your last word on this issue?
Okay, so I guess two things.
Yes.
One would be, one of the things I'm acutely aware of speaking to jurists and speaking to lawyers here is how your system, your judicial system, may be even more overwhelmed than our system. We have a much smaller population, and we're nowhere near the size of India. Yours is just of such great magnitude. We also have a state and federal system. We basically have more courts, and we have more judges, I think, per capita. And as a result, they don't have the sort of dockets. I was so surprised to hear that the Supreme Court has an immense docket each year. Your Supreme Court.
Just for your information, in India, I think it is 21 or 22 judges per million of population, whereas it is 125 in US.
125 judges for a million's population?
Yes, that is
the
difference.
I know under the constitution of my state, you get judges, I think it's 1 per 50,000 people.
So there's a lot of difference between our two democracies.
So that is amazing. So you have some challenges and some handicaps that we don't have.
Infrastructure issues aren't there, and you see the number of judges are more.
Right.
One question that I have,
Sure.
I mean, it just came to mind purely out of my curiosity. In India, there is a paucity of data which our judiciary can rely upon to deliver judgments. And many a times it's given out of whatever is presented before them. Is that a problem in USA? Or are there enough reports available on various issues which are well researched be.
Yeah, we have an extensive case when cases are now easily found. Used to be one time you had to only go to a law book and it could be
And that's
difficult.
where I would like to get Professor Kumar in,
Yeah.
because the role of universities is very important to generate such data. Does
So,
India
so one of the big challenges in India is that not only for courts to make judgments, even for policy making, I mean, evidence-based policy making or evidence-based judicial decision making is unfortunately not prevailing because most of it is opinionated.
Yes,
And
it's
so when you
opinionated,
have an
not data.
opinionated system whereby if you think, like for example, if you are, if you look at today's context, there is of course a legitimate fear among countries around the world about, I'm just giving this as an example, coronavirus as a major challenge that we are facing today. Now, if you look at, and if you base this current prevailing, phenomenon for policy making, you might end up getting very skewed results because we know that in India, approximately 650 people die every day due to road accidents.
Yes.
650 people die in road accidents every day. You calculate that, we're looking at 1.5 plus lakh per annum.
I've actually come pretty close to being one of those trying to cross the street in Delhi. So especially when we look the wrong, when you cross, we look the wrong direction. So I'm going to make sure I'm not one of those.
But if you look at, for example, some of these diseases, say the current ones, the number of deaths are far lesser. Now, what I'm trying to say is that we need to have a robust evidence-based policy making, but also judiciary to be presented with the data. Unfortunately,
The
both in terms
universities-
of legal research, lack of scholarship in relation to academic writings are relatively lesser because, and hence, judges also are most of the time presented with information from both sides of the lawyer
whatever they have to
community
decide.
and whatever
Yes.
they could, their clerks
that's
You
could
see,
That's
good
very
thing is
evolve.
now on some of the projects, I would commend many law schools,
They are
Care
doing-
Law School, including some national law schools.
Yes.
And the students are taking those projects.
They are
coming
coming up
out
with
with
data?
empirical research and on
Absolutely.
that basis data. And in some of the cases, they have intervened and they have provided that data to the courts.
I think Judge
Like
Wilson,
on-
I'm
yeah.
sorry.
And they have cited,
Yeah.
for example, the National Law School in Delhi
Delhi
on the
on
death penalty
death
matter,
penalty, yes.
on the 377 General
Yes.
Global Law School's own faculty members
Yes.
have been. So this is, but in a country where there are 1,600 law schools and so much of need for this kind of research coming out, unfortunately, it's woefully
And
inadequate.
I would
Weston, my
also,
colleague-
before I
sorry.
go to Justice
I'm sorry.
Cooper, no, before I go to Justice
Got
Cooper for a
got
question, I
excited.
would like to also make a point that the industry's involvement, industry has been wanting in its involvement in a sense to invest in these schools to fund such projects. I don't see industry in India really coming forward to fund such studies in universities, which I think may be common in US. I am not aware.
No, you are absolutely right. I would call it not just industry, generally the corporate business sector, including law firms, corporations,
They don't fund-
business
they don't
enterprises.
fund these studies.
They have seen law schools at best recruiting grounds for their,
That's all.
That's it. They don't see this as, institutional ecosystem.
But
for
I
research.
see now little silver lining. Few law firms I have seen
They are?
associating.
No, I'm not going to Justice Cooper, and we have little time left, so we'll go for a final round of questions. Should courts be in the business of making policy, or do you think that courts don't want to make policy? It is thrust upon them by executive inaction, and they are forced to play that role. And there have been many cases. For example, in India, there is big corporate lobbies which in a sense have disproportionate influence on governments across the world. Case in point is the midday meal program or the school food program, where many a times many corporate lobbies talk about serving children biscuits instead of nutritious meals. And you have had courts stepping in a sense saying, no, this policy is not right. You can't serve children biscuits, you better serve them meals. But this is a very small example. It can be in industries as diverse as mining to water supply. How would you look at this whole issue of courts making policy or interfering in policy making by governments?
The way I would look at this question is that certainly in the U.S., courts have been in the forefront of social change. And piggybacking on your question about law schools and data, some of the material that courts have relied on, some of the most valuable material have been law review articles done by students, because in law schools, that's where some of the greatest ideas come. You have young people who are confronting ideas. And so some of the social change and decisions that are distinctively moving progressive, what's called progressive, rely so much on law review articles, and I think Justice Wilson
You
would
have
agree.
relied upon them
Right.
for a lot of.
But yes, absolutely. But when you talk about social changes, one case comes immediately to mind. I think Michael would agree. Brown versus Board of Education, and that was a situation where we, as one of the vestiges of slavery, which was the worst stain on our history, we had an enduring stain, and that was legal segregation, not de facto, actually legally ordered desegregation. We had separate, quote, separate but equal schools that of course weren't equal, and they couldn't be equal because when you had black children and white children going to different schools, it was just wrong. It wasn't what we as a society needed. It was unfair. It was discriminatory. But that wouldn't have changed, or it certainly wouldn't have changed as fast if it was left up to legislatures. It wouldn't have happened, never would have happened in the South. It's hard to say if it would have happened anywhere. But it was because of a constitutional interpretation that was unanimous by the Supreme Court in Brown versus Board of Education that we had a sea change in this country. So in the U.S., that is, I think, the prime example of how the course of our society changed as a result of judicial, you can call it intervention, you can call it policy making. I would prefer to call it interpretation of the principles of our Constitution.
So you call it a living constitution?
And that is a major debate that's going on in the United States.
Versus
Yes, as there's said, textualism versus originalism. It is, and then there are those who say, no, you can't just be stuck by the words, or you can't just fixate what did a bunch of very smart and noble people back in the 18th century think. You can't look at that. Time has changed. You have to look at it in terms of an evolving constitution, a constitution that changes.
So courts
to meet
have the very difficult task of treading that path?
Absolutely, and there is a huge division between judges as to what methods applied, and I'm sure you have that as well.
This is a debate going on even today for the last number of years in United States.
Yes.
And the judges are divided. Whether to go by the text of the Constitution, and originalism means the Constitution in 1776 or 77, whether we should be stuck to that period and what was the framers of the Constitution thought about a particular provision, or it should be a living Constitution and we have to give the interpretation in today's times.
But Justice Cooper, do you face that dilemma when you are sitting in judgment on so many cases of relevant importance? Do you have that dilemma in your mind?
I think we always have that dilemma, and I think that's it, because we are not there to make the law, we're not there to write the law, we're there to interpret, enforce, but the question comes up, interpreting a living constitution might be a lot different than interpreting a static constitution.
But how would you see it in the Indian context?
You see, and I was telling you 3 stages, and I had not come to 3rd stage. I think this is relevant to 3rd stage of the PIL. When I said first was for the underprivileged and all those. Second was when of a natural environment and the protection of that. And the 3rd phase, if you see in last 15 years or maybe 20 years, that is on good governance.
Good governance.
That is where the court thought, and of course, going by that, this is what is expected of the executive and of governance of the country. And when I said to you about the directive principles of state policy, etc., which I mean, all these things of welfare measures are expected of the executive, and likewise day-to-day governance also, where the court started enforcing that principle of good governance. Now, in that sense, you take the example of 2G, take the example of coal cases, etc., where these, I mean, coal mines leases were given, or 2G spectrum which was assigned, etc. But the court found in those cases that, look, the manner in which it was distributed, it is not a bounty, that it is not the will of the executive, that person sitting there should, if I like your face, I should give it to you, if I like don't like Rajkumar, I should not give it to him. So therefore, it has also to be governed by the principles which are there in administrative law and which are well recognized principles how administration should be run. Now here, sometimes what happens, it is, I would say again, there are two, streams of cases. One is where fundamental rights or human rights of the people were to be enforced.
Yes.
There, sometimes policy is also made. Take Vishaka case.
Vishaka case, yes.
Where the court said that it is a sexual harassment at workplace, women's sexual harassment at workplace, and the court found that there is no law. Although India was signatory to CEDA,
yes,
but no domestic law is framed on that. So how to implement it?
Yes.
So that so in the cases of human rights, the court has gone to that extent, and have even in that case, the court said that this would be the law till the time Parliament enacts the law.
Oh.
So court even assumed the power of the legislature and enacted the
So
law.
you mean court is merely filling up shoes where the executive has no
That
attention?
this may be that second thing which has to bridge between the gap between the bridge the gap between the law and the society.
Yes.
So it may be that society needs it, law is not there, and we are telling the legislature. But what I am telling you is what I wanted, and say second case transgender, where I was party to that
Yes,
judgment,
yes.
and we said that there is no law for them,
Yes.
and this should be the law till the time. So in both the cases, no laws are made by the Parliament. So therefore, that is one. But when it has come to what I wanted to tell you was that when it has come to the enforcement of fundamental rights or human rights, and the courts have overstepped,
Yes.
that has been welcomed.
Welcome.
That because Vishaka judgment is one judgment which was, which got accolades throughout the world.
And that's why-
And even today, people say about that, yes, for the rights of the women and to give them their rights, it's a milestone, no doubt about it. But when it comes to day-to-day administrative functions of the government, and that power is assumed by the
You mean
courts.
water, power, garbage, all that?
That is not liked by the executive particularly. Of course,
but
subject
because
to
we are out of time, but I
Yes.
need a 30-second quote from you. Even though it's not liked by the executive, but if you see the people suffering, crying for help to the courts, should the courts turn a blind eye is what I want to ask.
No, I would say court should not turn the blind eye, but remedy is, and which I will quote, and I like that Rajkumar had written that article in one newspaper about 2 years ago, that take that cause, do it, but instead of doing it yourself, involve the executive and make them do that task.
Okay, okay.
So that it becomes
That's a
their
fair point.
task. You are not encroaching upon their power also, but you are enforcing them to do that.
Okay, so we're totally out of
yeah.
out of time.
Quickly,
but
I want to respond on one matter,
Yes.
on the matters relating to courts deciding on economic matters. In
Yes.
fact, Justice Sikri has a very good judgment on that. I have increasingly seen that even the highest court making mistakes.
Okay.
Unfortunately, the courts don't have enough methods to assess the economic matters carefully. They absolutely don't do law and economic analysis. They simply use their traditional understanding
Understanding
of
of the
law.
issue.
And unfortunately, serious, substantial matters that involve economic apparatus of the entire state, be it in 2G or coal or many others.
That I have commented in
On
one
our-
of the
in our last
programs.
In your
show.
previous, okay. He has a very good judgment on that. But those cause irreparable damage to the economic status of the country. And once the courts decide something, it becomes very difficult for executive
we were
to
lucky
do
because
anything else.
Justice Sikri had a very long comment on it in our last show.
So if
And,
you look at the European experience today, whenever when it comes to economic matters, courts are constantly looking at law and economic analysis. And we need to bring that into
That's where
our
data also comes in,
jurisprudence.
because empirical data is needed, in which we don't have. Justice Wilson, the last word from you on the show. Should judiciary be in the business of making policy, or is policy making thrust upon them by executive inaction?
Policy making is the duty of the court as directed by the Constitution.
Yes.
And that policy making is something that's expected by the people to decide what does justice mean
Yes.
under the Constitution. What does the right to privacy mean? What does the right to a clean and healthy environment mean? Those are policy decisions that are required by the court all the time. To me, this is a red herring. Courts obviously have to make policy decisions, but a more interesting question would be, how do they do? Because who else stands up for the disadvantaged?
Yes.
Who else stands up for those who are the victims of the law being applied improperly? So I would say in the overall context, the degree to which policy decisions are made is extremely healthy let's put it that way, and anticipated by the Constitution.
Okay, the frank observation by Justice Wilson. So that's it for this episode because we are totally out of time, but I would like to thank all my panelists today, Justice Cooper, Justice Wilson, for specially coming down for our show on a special request. Professor C. Rajkumar for, in a sense, ideating for this episode. In fact, I may like to acknowledge his contribution to the ideation of topic because we're generally not used to discussing episodes in a sense. Now we compared judiciary and democracy in these two nations, which is not the usual episodes that we do on Legally Speaking. Justice Sikri, as usual, has been kind enough at a very short notice to participate on the show. And thank you, viewers, for watching us and supporting us. And we will be back with more such episodes. But that's it for now. Thank you so much for joining us today. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.